for 5 minutes, Mr. Nadler.
Thank you, Mr. Chairman. Attorney General Clarke, when the Supreme Court struck down Section 4B of the Voting Rights Act in Shelby County, the court explicitly invited Congress to rewrite a new geographic-based coverage formula. What constitutional guidance should Congress draw from the Shelby County decision as it considers how to devise a geographic-based coverage formula to meet current needs?
Thank you, Chair Nadler. I think that the work that this body has been doing since 2019, the various hearings that have been held in Congress, the field hearings, this hearing today are all rising to the task that the court has asked Congress to undertake, really studying carefully and thoroughly and comprehensively current conditions across the country. And it is our view at the Justice Department that that careful analysis will yield a picture about where problems are starkest and greatest in our country, about the kinds of policies and barriers and restrictions that jurisdictions are resorting to most frequently in order to make it harder for voters of color to vote. So this work that is underway right now, I think, is incredibly important in doing what Justice Roberts asked Congress to do.
Thank you. Is the department's experience, is Section 2 litigation an adequate substitute for Section 5 preclearance?
Absolutely not, Chair Nadler. These cases are incredibly time-intensive, resource-intensive. Just by way of example, in North Carolina, the state spent over $10.5 million defending its discriminatory voting law that came under challenge following Shelby. The state of Texas spent over $3.5 million. Section 2 is no substitute for the important, swift, preemptive review that was provided by way of the Section 5 preclearance process.
We have heard testimony from witnesses that an overlooked consequence of the Shelby County decision is that it has impaired DOJ's ability to appoint federal observers, and that the department has come to rely on federal monitors who do not have the same authority to require local officials to grant access to the elections process. Do you agree with this assessment, and why or why not?
We do. For the Justice Department, the Federal Observer Program has been a critical tool in how we carry out our work of ensuring that all voters have access to the ballot. Federal observers were deployed by the Office of Personnel Management. These were independent, fair, neutral, eyes on the ground in places where there may have been reports about voter intimidation or other election day efforts to make it harder for people to access the ballot box. And so part of what we hope will come out of this process is restoration of the department's ability to deploy federal observers to communities where they may be needed.
Thank you. And one last question. Does the Supreme Court's Shelby County decision tell us anything about what kind of evidence the court will accept that demonstrates current needs if and when it reviews a new coverage formula?
Well, again, Chair Nadler, I think that this work that has started in 2019 and continues today shows that Congress is leaving no stone unturned in understanding what the problems are today, in understanding what the current present day conditions are. And as this work continues and as this effort kind of moves through the Senate, I think it will be plain to the courts that Congress has answered the call of ensuring that any post-Shelby remedy is a remedy that is responsive to the current conditions in the country.
Thank you. And lastly, what geographic coverage formula would you recommend to meet the current need, and why would it be constitutional?
Well, Chair Nadler, the Justice Department's view is that this is ultimately a call for Congress to make, and the Justice Department is proud to aid Congress's understanding of current conditions. I understand that there has been both a geographic coverage provision that has been discussed, that there's been a practice-based preclearance proposal that aims to look at the particular kinds of voting restrictions and rules that tend to be resorted to as ways to make it harder for voters of color to access the ballot box. Whatever Congress ultimately decides, we know, it must be a record that's justified. It must be a remedy that's justified by the record that you're developing. And so the department is proud to be here helping Congress kind of understand what that current picture looks like.
Thank you. My time has expired. I yield back.